it's very carefully crafted. My lords, we are a culture of my lords,
Perhaps-
Yashoda Mata and also Devki Mata, my lords. So
Perhaps-
both, my lords, one who gave birth and one who reared the child. Marriage as an institution, with procreation being such a fundamental core to it. If your lordships read spouse in the Special Marriage Act, my lords, it is going to have impact, my lords, that polycentric spider webs, my lords.
That has been already argued.
It's going to impact the children laws the most in ways that we can't even fathom today. Because children need that certainty of law, that conformity, my lords. And the only reason why any other relationship, though there are other kinds of relationships which are recognized in other laws.
Recognize 2 points which you have made. One, if a couple wants to adopt a child, then our adoption regulatory regime only recognizes the right to adopt when you are in a heterosexual marital relationship.
Please, my lords.
All right? That's your first point.
Please.
We understand why and what the public policy underlying that is.
Please,
That if you have to be a couple, if you have to be a mother and father, you must be necessarily in a heterosexual marriage before you can both adopt a child as a couple.
Please.
That's your first proposition.
Lordships.
What we are asking you really is on something slightly different, which is nonetheless, our law recognizes the right of a single individual to adopt.
Yes, my lords.
And the question therefore is, and we take it that's your position also, that the right of a single individual to adopt is not affected by the relationship which that single individual may otherwise have, whether it's in the nature of a live-in relationship, which is heterosexual, or a live-in or a relationship of a same sex. So long as you are adopting as a single individual.
Lordships. I bow down, my lords. That is my stated position. And my lords, your lordships will appreciate that because the law.
So we therefore take it that even a same-sex couple,
Yes, my lords.
or let me rephrase it, an individual in a same-sex relationship
Please, my lords.
is not precluded from adopting a child. We
Please,
take
my
that as Kara's statement of position.
Yes, that is the mandate of Juvenile Justice Act. That is the mandate of.
If I may just make one more statement,
Lordship.
you will agree with. A single parent
Please, my lord.
who adopts remains a single parent, there is no difficulty. The moment she enters into a matrimonial relationship
Please, my lords.
with, it's a heterosexual relationship,
Please, my lords.
then the husband becomes the father,
Lordships.
correct? The adoptive father, like she's the
Lordship.
adoptive mother. So then the child, as a consequence, becomes the heir in the event of death to the properties of either,
Yes, my
and
lords.
rather both.
Yes.
On the other hand, if the single parent enters into a same-sex relationship, then the adoptive child continues to be the adoptive child of that adoptive father or the mother,
Please,
and no more. Full stop.
Yes.
This is your proposition.
Lordships. My
What
lords.
you say is.
So
that
therefore,
it doesn't
sorry,
recognize
just to take one thought further, what you're driving at here is the stability. Because even in the event of disruption of the family, like in the case of marriage, there is a divorce. The relationship of an adoptive child continues.
Lordships.
Whereas since there is no marriage and there is no marriage recognition, that stability would be undermined if you recognize.
I bow down, my lords. I bow down to your lordships. My lords, Justice Narasimha had a point.
Same. I was
My lords, in
looking
fact,
at
Kara has
your argument.
a fast track method for step parent adoption also. It may happen that somebody has a natural born child and she becomes a divorcee or a widow and she remarries. So her child can be adopted.
Yes, by
There's
Right,
a mechanism that is.
yes.
My lords, it's very carefully crafted. My lords, we are a culture of my lords,
Perhaps-
Yashoda Mata and also Devki Mata, my lords. So
Perhaps-
both, my lords, one who gave birth and one who reared the child.
We will see those regulations. Perhaps there might not be anything formulated to say it's prohibited. But while hetero marriage might be recognized, same sex, the rules might not have provided any recognition. We will have a look at those rules.
Actually, my lords, that is why live-in is also not recognized, because live-in also is what Mr. Sybil was mentioning yesterday, the within, the concentric circles. The without is not recognized for live-in. Live-in are, my lords, now recognized under the Domestic Violence Act,
So a
120.
living couple cannot adopt a child as a couple.
Yes, because they can walk out
That's
of
fair
the
enough.
relationship anytime.
Fair enough. Fair enough. So we understand what
try
the
to-
public policy precept underlying it is.
Please, my lords.
But the existence of a live-in relationship does not prohibit one of the parties from seeking to adopt a child
Yes, my lords.
as an individual.
Yes, my lords.
So you're looking at it from the perspective of the child, which is that the
Lordships.
child is most benefited in every formation. At least there is one person responsible for that.
I bow down.
That stability is what you're actually driving at. And the
Lord-
core, at the
And
core
the
of
fact that one individual has adopted, that right to adopt or the continuance of that adoption is not affected by any subsequent change in the marital status of that individual who has adopted.
Please, my lords. Please, my lords. My lords, in fact, the ART and Surrogacy Act, the validity of some provisions are being considered by Court 5. There are a clutch of petitions that have challenged some provisions. And my lords, there was a point that was sent to the National Board for reconsideration. There's a very, my lords, well-equipped National Board under ART and Surrogacy. Because they are also, my lords, in a manner only recognizing this couple of heterosexual married couple as a relationship. And my lords, single women are allowed under the ART. And only widow and divorced women are allowed under
Then, Ms.
surrogacy.
Bhati, can we then summarize your submission in the following terms? That just as there is no recognition, according to you today, in the state of our law, of a same-sex marital relationship, which is legislatively recognized, parallelly, there is no recognition in our law today of the right of a same-sex couple to adopt a child as a couple.
Lordships. Yes, my lords. I bow down, my lords.
And that is based on the foundation that a child must have a stable family existence, which you postulate would exist in the case of a heterosexual marriage.
My lords, would your lordships just make a note of the sections that I am, my lords,
Yes.
giving to your lordships? The Juvenile Justice Act, my lords, I wanted to show to your lordships, it is at page 82 of my compilation A. I wanted to show chapter 8 to your lordships. And before that, I wanted to show some definitions and some general principles which are in section 2 and section 3. My lords, those general principles are very, very critical, my lords, from my perspective, because that is really an
Which is that? We said that provision.
Provisions you want us to see?
My lords, I want to draw your lordship's attention to some definitions in section 2 and general principles in section 3, my lords.
Which are the definitions section 2?
My lords, the definition sections, there are 3 kinds of children who are available, my lords, free for adoption. My lords, abandoned child, orphan child, or surrendered child. My lords, this is
It's 82 volume compilation 1, I think.
compilation A, my lords, we are calling it, and lordships will find it.
Printed 87 actually.
Yes, my lords.
Printed
Page 82
87.
it starts, my lords.
Printed 87.
Compilation, which compilation is this?
Compilation A, my lords.
Yeah, no? In a
Yeah. All right.
Also, 87 में?
Printed 87.
You have
It's
87.
index and 87 it starts, my lords.
87.
Yes.
So these 3 definitions, your lordships will note, my lords, abandoned child to 1. Then, my lords, please see a definition of adoption itself. Process through which adopted child is permanently separated from biological parents and becomes lawful child of adoptive parents with all rights, privileges, and responsibilities that are attached to a biological child. Best interest of the child means the basis for any decision taken regarding child to ensure fulfillment of his basic rights, needs, identity, social well-being, physical, emotional, intellectual development. Child means anyone below 18. Please see 15, child-friendly, 16, child legally free for adoption. Please now come down, my lords, to orphan at 42. Section 2, subsection 42, orphan. Then, my lords, 49, prospective adoptive parents, same as 57. Now, permit me to, my lords, take your lordship. A surrendered lordship will note is 60. Section 2, subsection 60 is surrendered child. And sponsorship, an example of which I gave, my lords, is defined at 58. My lords, the general principles, my lords, that are in section 3, there are total 16 principles, my lords. My lords, they've been culled out from the United Nations Child Rights Convention. And, my lords, I want to highlight to your lordships the aspect of number 1, presumption of innocence. My lords, the principle of best interest to develop full potential, principle of family responsibility, positive measures, my lords, and I want to read this one, my lords. All resources are mobilized, including those of family and community, for promoting well-being, facilitating development of identity, providing an inclusive and enabling environment to reduce vulnerabilities in children and the need for intervention under this act. This act is not to promote adoption. This act is to make sure that there are less and less interventions under this act.
You are reading from section 3?
Section 3, principle 6, I placed.
Sixth one, okay.
That's positive measures. My lords, your lordships will appreciate. Just reminding your lordships of X versus Union of India, my lords, judgment that my colleagues have relied on. In fact, we were fortunate that your lordships gave us the privilege to assist your lordships in that. Medical termination of pregnancy is the border in our respectful submission where the individual rights end. When it comes to, my lords, child that's already born or unborn in the case of ART and surrogacy, it's the welfare of child that alone is the underlying basic principle, my lords. So the parameters will be completely different. My lords, in Navtej, in X, in Nalsa, your lordships were dealing with competing rights. Marriage as an institution, with procreation being such a fundamental core to it. If your lordships read spouse in the Special Marriage Act, my lords, it is going to have impact, my lords, that polycentric spider webs, my lords.
That has been already argued.
It's going to impact the children laws the most in ways that we can't even fathom today. Because children need that certainty of law, that conformity, my lords. And the only reason why any other relationship, though there are other kinds of relationships which are recognized in other laws, go to, my lords, great lengths to protect their children from when they can vote, when they can marry, when they can drink, when they can. And, my lords, the right of repudiation, the right of non-waiver of rights. These are the principles on which they have all been founded. The right to a fresh start, the POXO Act, the entire architecture, consent is immaterial. An independent thought, your lordship said, even a minor spouse would be covered. The entire, my lords, architecture of your lordship's judgments and the statutes has been from the prism of the child and none other.